Alrighty, I'm guessing this is about how many people we're gonna get since it's like the day before spring break. So, um, we'll go ahead and get started, and see if maybe a couple people will sign on Zoom as well. So just wanted to, if I can get this to show, hang on. Yay, okay. I wanted to throw up the syllabus and kind of remind you of dates coming up here. Today, your midterm report for your service learning project is due. Again, that's just a couple sentences, and even if it's just, I haven't started my hours yet, I'm still figuring it out. Turn it in, you get the points. I believe the week after spring break, I have midterm progress reports due. I will put in placeholder zeros for anything you haven't turned in. That doesn't mean you can't still turn it in and get full points. I just want you to let you know, like, if you didn't turn anything in, you haven't turned in, here's what your grade would be, right? Just to be like a little bit of a wake up call for some folks who might not have gotten anything in yet. But then I'll take the zeros away because you do still have, in theory, till the end of the semester. The other thing to be thinking about is that midterm. So it's due 2 weeks from today. And again, it's a series of short answers. And it's really meant for you to show me your knowledge of what we've looked at, what we've talked about. There are probably a couple questions where our answers to the assignments from class may be helpful. So just a reminder that not only are these links here to the assignments themselves, but these assignments contain all of your answers as well. So you can look at the group's answers as you make your own informed decisions and informed answers to the exam. So again, to remind you, if you go to take home exams on Blackboard, that's where you download the midterm, put it in your word processor, answer each question. Here, I can download it real quick and show y'all what it even looks like. And Sadie or Karen, sorry, you won't be able to see it. Sadie, you won't be able to see it because I'm not showing the whole screen, but you can download it yourself. So again, just very brief little short answers. Think about a paragraph essentially to answer each. And then you'll see sometimes it's asking you for examples from readings and class discussions. So pull from those. And again, that's due by uploading it to Blackboard 2 weeks from today. And you've got till midnight on that day. The other thing, again, to keep in mind is the service learning project. All of these places for each assignment are here. So if you haven't done any yet, catch up on those. If you're maybe behind one or two, catch up on those. So everything's here. If you click on it, you just turn in your assignment there. You can either write submission or you can upload. If you can avoid it, don't type it in comments, because when I go to grade, if you put it in comments, it comes up really small, the column about this wide. So it can be sort of hard for me to read. I'll still grade it, no problem, but again, try to do it that way. The last thing I want to remind you of, I am about a week behind, so I'm going to try to catch up with these, is that I have a whole YouTube playlist of class lectures. So if there's anything you have missed, they're arranged by date. So as you can see, I'm only up to about the 23rd now. I will get the rest of them up at lunch today. Alrighty, any questions about anything coming up due? Awesome. All right, please stop me if you have any, shoot me an email. But also, if you get the chance, don't think about class over spring break. Like, enjoy yourselves, relax, take naps. Go to the very cold beach. I took a walk on the beach this morning. It was very brisk, but it still felt good for the soul. So we were finishing up an assignment about Lie to Me on Tuesday at the end of class. So go ahead, if you were in a group, go ahead and regroup with your group. If you weren't in a group, feel free to just join a group and chat about it. I think people were getting close to being done. I'm going to open it real quick to see where folks were at. And this is group assignment 6, and again, it's posted on Blackboard. Group 1 already rolled through. Actually, it looks like everybody at least had something for all the answers. Does anyone feel like you need more time, or do people feel good? Thumbs up. All right. Sweet. Y'all are like much more on top of things than I am sometimes, and I very much appreciate that. Okay. So I'm just zooming in here, and I'll just go down and have group 1 do the first one, since I haven't had a chance to look through and see who had the most fleshed out answer. So Julia and Haley, what was your group's initial reaction to Lie to Me?
I thought, or we thought that was kind of a mix between science and science fiction. There definitely were a lot of real like behaviors and computers that he was using because of these techniques, but those are kind of being more dramatic just for the so you're kind of a mix between.
Yeah, and I think that sounds spot on with what Ekman says, which we'll talk about in a couple minutes. Yeah, that it's like, sure, there's some science behind it, but you need a lot of training to be able to do it. So you could imagine this in the wrong hands going horribly, right? Alrighty, so group 2, and this was Michaela, Haley, Trinity, and Sydney. After reading the blog post, what do you think of the science behind it? Does it seem like the show gets it right, or are they kind of off on it?
It's like much get it close to right down and then should get back correct because it's like but like looking at the micronutrition
Yeah. Alrighty, group 3 was Elijah, Cameron, and Mayu. What would be some of the dangers of, is that right? Did I skip it? No, that's the second question here. Okay. After watching the show and reading the blog, how do you think detection of microexpressions might compare to more traditional methods like the polygraph?
I think if there were like science that obviously were accurate given the different introductions like the microexpression, but without the science or evidence that it's actual, they're pretty terrible.
Yeah, I mean, this could be just as bad as a polygraph, right? If someone who thinks they know what they're doing doesn't. I'm spot on with that. I totally agree. Alrighty, and then group 4, looks like Kayla and Sadie were both in this group. So then the next question was, what are some of the dangers of using interpretation of microexpressions, blah, 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 in detecting deception? So I don't know if you want to answer, or Sadie, if you want to unmute.
I think that there's misinterpretation of one's facial expression as some versions are similar to one another. Microexpressions last less than a couple of seconds, so it'd be very easy to read one wrongly or interpret a simple twitch in one's face.
Yeah, I think you're totally spot on with that, right? Like, this is one of the reasons why they keep recording it so that they can verify it. And yeah, you could very easily overread these. You know, there was when he was giving the seminar at the beginning, there was the person who said, aren't these different for people? And like, in general, no. But let's say you have a facial deformity, or you've had a stroke and one half of your face is paralyzed. Or people who are psychopaths. They actually address that in a later episode, that Lightman has a hard time reading people who are psychopaths, not surprisingly, because their whole shtick is masking, right? So they get good at masking even beyond that. And then I'll just sort of scroll through and look at all your answers for number 5 here. Microexpressions, ooh, psychologists and therapists. I love that. And doctors, especially for kiddos who can't communicate things. Workplaces, personal situations, psychiatrists, a lot of people were thinking along those lines. Anything in court and meeting with lawyers, yeah. Relationships with significant others, yeah, you saw that where it was pretty obvious that the main woman whose name I'm blanking on her husband was cheating on her, right? So does this become weaponized in theory? Yeah, I don't remember from the show. I was trying to remember if his daughter was what Ekman refers to as a wizard, what they call in the show a natural. Or if she's just sort of like picked stuff up from her dad. But there was that line where she was like, you're doing the thing with your eyes, right? Like she can do it too. And so you can see how you might like weaponize that against your family in theory. Excellent job, y'all. Great diving into that. So what we're going to start talking about today, I think is probably one of the things that's going to be most interesting to a lot of you. And this is when psychologists actually engage in assessment in criminal settings. So I'm going to go ahead and do one thing on the Zoom here. And I just realized, hello Zoom folks, I just realized I never shared screen with you, so I apologize for that. But hopefully you could follow along with the assignment. And I'm going to go ahead and turn on the captions because I've discovered if I do that, then I can actually upload them when I upload it to YouTube and it creates captions. YouTube used to do that automatically and they don't anymore, and it's really annoying. For accessibility purposes. Okay, great. So glad to see some other folks on Zoom. I'm just trying to, there we go. Oh my gosh. Zoom. Please, I know you want a spring break too, Zoom, but the rest of us need a minute. Okay, so I'm going to go ahead and put this into presenter mode and we'll start talking about it. All right, just double check. There we go. And then turn this back off. Alrighty. So this is where we think of psychologists being involved in the legal system the most often. These are where you might actually testify in court, and you might be the person to actually interview someone who's a psychopath, or interview someone who you know, is, did they commit the crime? Did they not? Are they lying? Are they trying to get out of it? Things along those lines. So we're going to start by talking about competence to stand trial. And this is the one I think people are probably a little less familiar with. A lot of people know about not guilty by reason of insanity, and we'll certainly spend lots of time talking about that after break. But competence to stand trial is a really important one, not only just from a psychologist's involvement, but also because the justice aspect of it. Part of the US justice system, really one of the big things of the US justice system, is predicated on the fact that it's fair and equal. We know it's not always, let's be perfectly honest. And in fact, in the US, there are systemic racial particular issues against people with mental health issues, right? But it's predicated on the fact that you're able to comply with and understand what's going on during your trial. So if you actually can't do that, then we have a grave, miscarriage of justice. If we are having people go through a whole trial and they have no idea what's going on because of mental health issues, justice has not been served, right? Because they can't come to their own defense. All right, so some history here. So this idea of competence to stand trial is originally from English common law, as a lot of our things in the US law are. So in the 17th century in English courts, defendants who stood mute were sort of analyzed. And they could be considered mute by malice, where they're purposely staying mute, or mute by visitation of God, which was sort of their key word for mental illness. And if it was the latter, if they were mute by visitation of God, they didn't have to enter a plea innocent, guilty, anything. In 1790, there was Fritz's case. And in this particular case, the court delayed the trial until such time as the defendant, and this is big and in flowery language, so I'll translate it after I say it, but quote here. By collecting together his intellects and having them entire, he shall be able so to model his defense and to ward off the punishment of law. So basically, they gave the defendant time to sort of try to be remediated so he could actually participate in his own defense and his own trial. It's been argued that this whole idea of competence to stand trial falls under the Sixth Amendment of the US Constitution, which is the right to assistance of counsel. If you cannot actually assist your own counsel, right? Or you don't understand what assistance your counsel is offering you, we're not in compliance with that. And in 1899, there was a US case, Utsi versus US. Utsi was someone who had epilepsy. And he was unable to go on trial for embezzlement. And the argument was it was doubtful whether the accused was capable of appreciating his situation and of intelligently advising his counsel as to his defense, if he had any. So again, similar to Frith's case, argument being made here, this is not justice. This is, we need to like figure out a way or just not try this person. So what's the legal basis for this? One is accuracy. The accuracy of justice, of our criminal proceedings, in theory, depend on the assistance of the defendant in the trial. Now, again, I want to fully acknowledge there are plenty of cases where there are other reasons why it is not accurate, right? I think I've mentioned in passing the idea that public defenders often only have about 7 minutes to prep for each case they have, which is obviously inadequate, right? So if you are someone who is of lower socioeconomic status or honestly even middle-class status in the US, you might not be able to afford your own counsel, right? Your own legal representation, and that's what you're left with. They also focus in on due process, and that depends on the ability of the person who's accused to exercise their rights. Then there's the integrity and dignity of the process, and the argument is it's undermined by the trial of incompetent individuals. And the objective of the courts is not served when the defendant doesn't understand the punishment. And that feels fair. So when do we raise this idea that someone might be incompetent to stand trial? And the idea is when there's a bona fide doubt. And this is from a case in 1966 called Pate v. Robinson. So any person within the trial can raise the issue of competency. So the judge can raise it, the defense attorney can raise it, even the prosecutor can raise it if they're worried about the ethics of the process. The person themselves can raise it. Anyone involved. But then the judge decides whether there is a bona fide possibility of incompetence. If they think there is a possibility, the bona fide doubt, the judge has to order a competency evaluation by a psychologist or a psychiatrist. And then the court pays for the evaluation. So that means the financial burden's not on the person, but it also means the court is the client. So nothing that that person who comes in for their competency eval says to you is incompetence. So if they come in and they tell you they did it, right? Like, you have that information now. Either side can ask for an independent evaluation after the official court-ordered competency eval comes in. So either side can say, I don't agree with that. I want an independent person to evaluate them. And this is often by the defense after they see the results for the first evaluation. If it says, oh yeah, this person totally knows what's going on, they'll question the conclusions. If that happens, the defendant pays for the independent evaluation if they have the resources to do so. If not, the court will also pay for the independent evaluation. Then there is a separate trial to determine competency. So separate from the main, murder, whatever type of criminal trial we're having, there's a trial just to determine, is this person competent to go through with the main trial? And what percentage of cases? This is one of those things like not guilty by reason of insanity that unfortunately the media exaggerates how often it's used. So in movies, on shows, even the news will bring up if this is brought up. And so people think this is happening all the time. But in fact, the issue is only raised in 2 to 8% of federal cases. So that's just it being raised. That doesn't mean those people are even being found incompetent. And in about 5% of all criminal cases. About 2/3 of the cases where it's raised, so 2/3 of that 2 to 8% are even referred for a competency eval, because remember, there has to be this bona fide doubt. So the judge can be like, there's no bona fide doubt, this person is clearly competent. Of the 2/3 that are referred for the evaluation, only 1/4 of those are actually found incompetent to stand trial. So less than 1% of criminal cases are actually found incompetent to stand trial. That's very, very seldom. There's an important note here where the defendant is assumed to be competent until proven incompetent. So it's sort of the opposite of like being innocent until proven guilty. The burden of proof here is on the defendant. They have to prove they're incompetent. So what are the criteria for competence? How do we determine whether someone is competent or not? Well, again, like many of the other things we talked about, we look at case law, case precedents. So Dusky v. US in 1960 said that they have to be able to consult with a lawyer. Again, that goes back to the 6th Amendment of the Constitution. They have to have a present ability right now to consult with a reasonable degree of rational understanding. And note here, this is not, they have to have a law school level understanding, because no one in this room would, right? Because none of us have been through law school. Maybe some of you will, which is awesome. But it's just, they have to have what the average person, so reasonable is what the average person involved in a court proceeding would understand. So they don't have to understand all the legalese, they just basically have to understand what's going on. As part of that, they have to understand the charges against them. They have to have a rational and factual understanding of the procedures against them. So they have to realize, I'm being charged for murder, right? So if it's a murder trial and they're like, oh, I'm here because I stepped on my neighbor's petunias, right? We need to do a competency eval probably. Then in Weider v. Settle, this was a follow-up to the Dusky case, and they articulated the components of competence in more detail. So they have to be oriented. Oriented means you actually understand what's going on. So oriented to time, like what day it is, what time of the day it is. Oriented to place, where you are. I'm in a courthouse, right? And oriented to things in relation to themselves. So they have to recognize they're in a court, being charged with a criminal offense. And then just understand basic components of the trial. Understanding there's a judge on the bench. Understanding that there's a prosecutor who's going to try to convict them. Understands that they have a lawyer who will try to defend them. And they will be expected to tell their lawyer the circumstances of the crime to the best of their mental ability. If there will be a jury present, they also understand that and what the jury does. And that we're looking at, do they have the ability of memory enough to be able to relate these things? If I ask, okay, what does the jury do? Can they tell me? And then in Cooper v. Oklahoma, which was in the 90s, they came up with a competency standard. And this is preponderance of evidence. So some people will say this is 51% certainty. I've also heard people say it's 50% plus a feather. It's a fairly low standard. So it's not beyond a reasonable doubt. It's basically, you know, if you seem confident, we're rolling with that. And again, this is why so few people actually end up this way. So, okay, I'm a psychologist. I've been assigned this competency eval. What do I need to be thinking about? What am I going to do? What steps am I going to take? So the first thing we look at is foundational competence. Does the defendant understand the proceedings and the possible outcomes, right? If you're being tried for murder one and you think, oh, they'll just have, like, the worst thing that could happen is they're going to give me community service, and you're in like a death penalty state, right? That's problematic. You could understand what the potential consequences are. And again, this is reasonable understanding. You're not supposed to know all the legalese or the exact terms of a possible sentence, but just knowing, like, I could go to jail. And then there's decisional competence, and that's the competency to make decisions during your trial. Can you cooperate with your attorney in preparing your own defense? In most jurisdictions, psychologists also need to assess if the person is deemed incompetent. Can they be restored to competence in what's determined as a reasonable period of time? So in the vast majority of cases, it's not like, oh, you're incompetent, so we're just going to let you off. Instead, what they do is they give them very specialized training to get them to be competent. And the psychologist has to determine, can that be done in a reasonable amount of time? All right, so the actual evaluation, the first thing you'll get is the court order, right? So you'll get information from the court order or referral. And then you will talk with that person's attorney and get their opinion. Does it seem like the client is able to cooperate? Ask them about why or how this person is potentially considered incompetent. And you don't necessarily accept what the attorney tells you as fact, right? I mean, attorneys are going to be speaking in the best interests of their clients. But this is a useful piece of information. It's a jumping off point. Then you're going to do an interview. You want to just ask them about general clinical topics, essentially like you would if they came to your office for therapy. You want to ask open-ended questions, but then you also want to ask them about the process of the legal system, and you see how much the individual can give you without prompts. You ask them, what's going to go on during your trial? Do they mention the judge, the jury, the lawyers, witnesses? Do they understand the basic process? Example, you might ask a question of like, what do you do if a witness says something about you that isn't true, right? And the person, if they're competent, should be able to say, you know, I get upset, but there's nothing I can really do in the moment. Rather than I'm going to run up and punch them, right? You ask them questions like, do you understand why you're here today? And if they don't understand it, you want to make sure you tell them the purpose of the evaluation in detail. And you're also ethically obligated to let people know what will happen to the information they tell you. It goes to the court and they'll also distribute it to both attorneys. So nothing they're telling you is in confidence. And then you're going to administer a standard competency instrument. And these are standardized. These gather information to help you make decisions about if the person understands enough. And again, remember, we're looking at, do they understand as much as the average person? Do they understand a reasonable amount, a substantial amount? And then you will prepare a written report for the judge. So what goes in it? And that's what the second column is. First thing is reason for referral. So not only competency evaluation, but why they thought this person might not be competent. Is it that they're hearing voices? Is it that they have a very low IQ, right? What's going on with this person? Do they have amnesia? Then you are gonna do your sources of information. Talk about anyone you interviewed, the client, the attorney, if you talk to anybody else in the client's life. You're gonna talk about the assessments you did, any records you reviewed. Then you're gonna talk about the client's background. Age, history, education, family background. Then you address the question of competency. And again, here's where you're gonna bring in all the information you have, the interview you did with that person, the test specific to competency you gave, conversations with their attorney, conversations with their family. You'll talk about how much they understand. You can say things like, this person doesn't trust their lawyer, and describe any delusions or hallucinations they're having. This person doesn't trust their lawyer because they believe that they're an alien from outer space trying to mind control them. That's going to give you pretty good evidence that this person is probably incompetent at that time, right? And again, these are rare, just like schizophrenia itself, which is what those symptoms would typically come from, is also rare. Then you say what you have concluded about the individual in relation to aspects of competency. And this is where it diverges based on what state you live in. So in some states, you are not allowed to address what they call the ultimate issue of competency. You basically can address all the elements. They understand what a lawyer does. You know, they understand why the judge is there. They seem to be able to communicate with their attorney effectively. And it basically like points to this person is competent, right? But you can't actually say, therefore, I believe Mr. X is incompetent or Ms. Y is competent. But most states permit and in fact require psychologists to address that issue. So in most states, the psychologist not only is allowed to address the ultimate issue, but in fact is required to address the ultimate issue in their report. And this is one of the reasons why you, regardless of what you're going to do as a psychologist, if you're going to be in an applied setting, doing therapy assessments, what have you, you have to get licensed in your state. And part of that licensure is an exam on the laws of that particular state, so that you know this stuff. And you can show, this is what this is what I'm allowed to say, not allowed to say. If they're found, and if you, regardless of whether you're like allowed to say they're competent or not, you must address restorability. So can this person be brought up to be competent in a reasonable amount of time? And that can be hard to address if you haven't said this person isn't competent, right? So that you have to be much more clear in the states where you're required to say that. You don't address what needs to be done, just say they can be restored or not. But if they're found competent and you're allowed to say that, that's it. There's no recommendation. You're just like, this person is competent to stand trial. Boom. So, okay, I mentioned and kind of like did a one-off with the competency instruments, right? We're going to talk about those in a lot more detail, as well as some of the other things you might use. And I just realized there is a typo on this screen, so I'm just going to fix it real quick. There we go. Okay. So competency exams are where standardized instruments are the most helpful in general, because they evaluate someone's status right now. And that's what you're determining when you're determining competency. Right now, in this moment, is this person going to be able to participate in, understand what's going on with their trial? When we talk after spring break about NGRI, we'll see that that's much trickier because you're trying to determine mental state at the time of the crime. You're being like a psychological detective, and that's really tough to do. For competency, the vast majority of our instruments are made for assessing how someone is doing right now, so that makes it easier. So what's recommended is that you typically do one general instrument and one specific to competency. So you might do the Wechsler Adult Intelligence Scale or WAIS. And this is a highly standardized assessment of intelligence. It's considered the gold standard if you're going to be assessing IQ. And you look at their level of general intellectual ability in relation to the norms. However, IQ itself isn't going to answer whether the person's competent, right? You can have an IQ of 120, which is quite smart. You for sure have the intellectual ability to understand, but that doesn't mean you don't understand the specifics. And it doesn't mean you're not having some sort of psychotic symptoms interfering with things, right? On the other hand, you could have an IQ of 70, which is considered to be of limited intellectual ability, but still understand what's going to happen during your trial, not necessarily be considered legally incompetent, right? So this only gives you like one piece of information, and what you really need are these tools specific to competency. So one example is the MacArthur Competence Assessment Tool, Criminal Adjudication, the MACCAT. Psychologists love their abbreviations, y'all. So this is the one that's most often used for competency evals. It's got 22 items and they're scored 0, 1, or 2. And it addresses both knowledge and understanding. So what do they know and what do they understand about the criminal proceedings? And also their ability to reason, which gives us their capacity to understand new information. And those are separate subscales. There are norms that can be applied, however, they have limited data. Again, these assessments are done so infrequently, right? There are no validity indices, however, and validity indices are things that you can give to people to try to figure out whether they are lying. So for that reason, you usually have to administer another test to try to get at that. Then there is the MACSAC-CD, or the MacArthur Standard Assessment of the Competence of Criminal Defendants. And this one is sort of interesting where it shows a vignette, so a little story about which the defendant is asked 82 questions that tap foundational and decisional abilities. So defendants are asked open-ended questions first. And if there's a wrong answer, the correct information is provided to the defendant and the defendant is questioned again. Yeah. Oh, legit question. I don't have sample items, but let me Google it real quick and see if I can find one. Right. Alrighty, let's see if they've got sample items. A couple different links here. Okay. Looks like there's no sample items. And yeah, exactly. Like it's probably because they don't want people to know the questions before they go in. Yeah, so here you can see some of the norms. 729 defendants. You know, normally we want norms in the tens of thousands, but that's how many people we can get. But yeah, it looks like there are not sample items.
But I don't know, you know, like the dark triad test or whatever, like a personality. I don't know what that plays.
Good question. I don't know what the psychometrics on it are. Basically anything you use that's I'm gonna just Google it on my phone so I don't have to go back in and out. anything that you use in a court situation, you want to have really good research behind it, because you're gonna have to stand up and defend its use on the stand potentially, right? So if it has, good research behind it, yeah. If it doesn't, probably not. Taking a look. There's okay. Maybe because the the original article presenting the dark triad measure was published in the journal Assessment, which is the leading journal of assessments in psychology. I don't know if y'all know what the impact factor is, but impact factor is basically like an indication of how many people are going to read it or be influenced by it. And usually for a journal, if you're somewhere around 3 or 4, that's a pretty good impact factor. And I think for assessment, it's close to 10. So yeah, probably then. I don't know if they would specifically for this type of question, but maybe for other questions for sure. Yeah, so you want to make sure it has good backing, and these do. And then the MACCAT-CA, I'm going to refer back to that again real quick, is a 22 item clinical version. And it begins with a hypothetical vignette about a crime. And then the first 16 items are based on that. And these items assess the defendant's general understanding of the legal system and the adjudicative process, and their reasoning abilities in legal situations. And then the thing I like about this is the last 6 items are specific to the defendant's own legal situation. So that really is, are they competent to stand this particular trial? Now, what other types of assessments can be used and are used in these? And again, these will help you to determine other specific questions. So the MMPI, the Minnesota Multiphasic Personality Inventory, gives you things like level of adjustment of that person, the presence or absence of severe psychopathology. Essentially, does this person seem to be significantly psychologically distressed or not? But it doesn't address the specific issue of competency. Now, that being said, one of the advantages of the MMPI is it does have validity scales embedded within it. So that will tell you, is this person trying to look better off than they are? Are they trying to look worse off than they are? Things along those lines. Are they just not paying attention? The PAI is a similar personality inventory that's also widely used. The VA uses the PAI most of the time when they're doing major assessments. And again, it does have validity scales embedded, but similar to the MMPI, it's not going to be able to actually tell you whether the person's competent or not. It just gives you evidence about their levels of psychological distress that can help inform your decision. Projective tests, things like the Rorschach ink blots or the thematic apperception test, not used. There's no research backing for this particular question in particular, but also there's not a ton of research backing in general with projectives. And so to use them would invite a lot of criticism and probably make jurors just ignore the rest of your report. So the vast majority of time, we're not using those. Then there are other competency instruments that can be used. So the competency screening test is a 22-item sentence completion task that's designed to be an initial screening for incompetence. So this it's not as diagnostic in terms of incompetent versus not as the MACCAT ones, but it does give you an indication of sort of where you should be leaning. The competency assessment instrument, or CAI, is a more in-depth instrument. It's a structured 1-hour interview that covers 13 distinct functions relevant to competent functioning at a trial. The Georgia Court Competency Test, or GCCT, involves 21 questions that have 3 dimensions: general legal knowledge, the layout of the courtroom, and again, kind of similar to what we were just talking about, specific legal knowledge relevant to their particular case. The evaluation of competence to stand trial revised, ECSTR, is a semi-structured interview. So that means that there are standard questions, but you can kind of riff off them. That was developed using the Dusky criteria. And that, just as a reminder, is that can they understand the factual, do they have the factual understandings of the proceedings? Do they have rational understandings of the proceedings? And can they consult with their lawyer? Unlike others, this test for the whole thing uses information specific to the individual's case. And has a measure to assess possible exaggeration embedded within it. Estimates of malingering, which is faking or grossly exaggerating, mental illness in competence evaluations are about 18%. Then there's the MFAST, or the Miller Forensic Assessment of Systems test. And this is a 25-item structured interview that can identify individuals who are attempting to feign mental disorders. So that's a lot. There's a lot of options. You're probably going to do one of the MacArthur ones, but you might want some of these other things to fill that in. So you want to adopt a comprehensive approach. You don't want to just rely on one data source. And again, certainly you don't want to just rely on test results. You want to also make sure you're interviewing the person, the lawyer, other people around them. So, okay, you've done your eval. You've got your report. You're giving it to the court. Who makes the decision about competence? Well, it's the judge. And as I mentioned, at a separate hearing. And that's based on the evidence from that report, from the competency evaluation. The defendant is present at that hearing and represented by counsel, which in my mind actually brings up a really interesting question, because if that person is incompetent to stand trial, now we've got them going through another trial that we've already established they're incompetent, right? So like, is that justice? I don't know, right? That's above my pay grade. But the trial will include any evidence about competency from the defendant, the attorney, and that psychologist. That being said, the written report is almost always accepted in these cases into evidence without the psychologist testifying. Typically, they look at the report, they're like, cool, we don't need to ask any questions about this. The psychologist has been very thorough. And so they just use that without that person having to be in court. Again, I think a lot of people are disappointed when I say that, because for big trials, like the Amber Heard Johnny Depp trial, or trials we see on TV, right? The psychologist is always on the stand and, yelling about things. And a lot of times you're actually, after you do the interviewing, which is the really interesting part, you're like writing up very careful reports in your office, right? Not as exciting, but just as important. So if the person is found competent, the trial just proceeds as it would have been, as if the issue never came up. And it basically starts where they left off in the proceedings, where the issue was raised. So if they are found incompetent, now it's going to depend on the prediction of restorability to competence. And so again, this is why this is really important in the psychologist's report. So if the psychologist says this person, maybe they just have a super low IQ, they've had a traumatic brain injury, they're not going to be able to get there. And then there's a couple different things that can happen. One is that they are civilly committed. This is a separate civil proceeding where if they meet criteria for what's called involuntary civil commitment, where they're considered dangerous to themselves or to others, then they will go to a forensic mental health facility. They are regularly reevaluated to determine if they continue to be a clear and present danger to themselves or other people. And it used to be that people would just stay there for the rest of their lives. But now they're typically released. But unfortunately, we know the recidivism rate is really high because typically, let's say they're medicated while they're in this facility or they're getting treatment. Once they're out, they don't have the resources to continue being medicated or getting treatment. And so we often see these folks ended up hospitalized for their mental illness or in jail again later. In rare cases, where, it's just clear this person didn't know what was going on, the charges are just dropped. And this was not a competence to stand trial issue, but I think the clearest example I can give of like when this would happen would be the case of the, 6-year-old in Newport News who shot his teacher. Like they are not pressing charges against him because I said this kid clearly didn't understand that this could potentially kill her, right? This is something that like is more implicated on the parents than anything else. So in the same way, if you just realize like this person is not going to benefit at all from ever going through the justice system and they're not a danger to themselves or others, the charges would just be dropped and they'd be released. If they are considered restorable again within that reasonable period of time, then they are treated. They're sent to a criminal psychiatric facility. And that reasonable period of time has been delineated in the case of Jackson v. Indiana, which was in 1972. So serious crimes like murder, sexual assault would be 1 year. And then less serious crimes would be about 6 months. There's no general mental health treatment here. The focus in these situations is just teaching people how to be competent. It's basically like competency boot camp for however long it takes. So then they're periodically evaluated by the court to determine if they are restored to competency. And this can be done by recommendation of the treatment facility. They can say, hey, this person's made a lot of progress. We should evaluate them again. Or sometimes the court will mandate it at regularly scheduled intervals, like every 6 months, we're going to test them again. So then they would do another full competency evaluation. And it could be the same person, but oftentimes it would be someone else who works specifically with that facility. If they're found restored to competency, they go back and they stand trial. If not, and if it's not done within a reasonable time interval, the person is sent back to treatment. And if at the end of that time period, if they weren't done with the reasonable time, so like let's say they committed murder and it's been 6 months and they're still found incompetent, they got still 6 more months to try to get them competent. So then they would go back to the treatment. But if they're done with that time period, let's say it's been a year and they're still incompetent, they are then switched to be considered never restorable, just like this bullet here where they can't be restored. In that case, they would either again have the charges dropped if they're not considered a danger to themselves or others, or again, they would go through the civil commitment procedure if they were a danger to themselves or others. And a large proportion of people found to be incompetent are eventually able to be restored to competency. And again, remember, this doesn't mean we've magically made their IQ higher or fixed their schizophrenia. What it means is, do they have an understanding of the criminal procedures enough to assist in their own defense? So about 70% of the defendants referred for evaluation for competence are ultimately found to be competent to stand trial. So that being said, who amongst these folks, what sort of person is most often judged to be incompetent to stand trial? Sometimes you'll see this abbreviated IST. The typical defendant, as we've mentioned a couple times already, has a history of psychosis, whether it's schizophrenia or another cause of hallucinations, delusions, things along those lines. They also exhibit symptoms of a current serious mental disorder. Remember, for incompetence to stand trial, we're looking at right now, how are they doing? They tend to be single, unemployed, and unfortunately poorly educated. This can be for a whole host of reasons: socioeconomic status, if their psychological issue is a long-standing problem, right? They may have dropped out of school just because they had a really hard time participating. And maybe not surprisingly, and again, validating, for our assessment procedures, they score poorly on competence assessment instruments. There you go. So there are some other special considerations that we need to think about. So mental retardation is a legal term. We don't like using it psychologically anymore because of all the negative associations being used with the R word. It's basically a slur against people with developmental disabilities now, but it's still used legally in a lot of jurisdictions. So if you have a low enough IQ to meet criteria for MR, that doesn't necessarily mean you're incompetent. It shouldn't be assumed either way. You should evaluate that person with the same criteria as anyone else who's being brought up as potentially incompetent to stand trial. Another issue that we need to take into account is communication deficits. Is this person deaf? Are they mute or unable to speak for some reason? Or do they have no language at all or no English? Well, in those cases, the court must provide assistance. They must provide an interpreter. So whether that be for the foreign language, for American Sign Language, things along those lines, or other accommodations. So for example, if the person is blind, then they should provide descriptions of things or let them feel physical objects that are relevant, rather than expecting them to be able to see when they can't. So those wouldn't equate to incompetence to stand trial. They would just mean the court is legally obligated to provide the appropriate accommodation so the person can participate in their own defense. I mentioned amnesia in passing earlier. So amnesia means loss of memory. Sometimes it's short term, sometimes it's long term. Sometimes what we tend to think of when we think of amnesia is what's called retrograde amnesia, which is where you forget past memories. But you can also have something called anterograde amnesia, where you're unable to make new memories. Right, so all these things can affect it in different ways. And there was a case in 1968, Wilson v. US, and basically they said amnesia doesn't automatically make you incompetent to stand trial. So we need to consider a host of factors in deciding whether fairness and accuracy of a trial will be compromised by someone's amnesia. So one is the extent to which the amnesia affects their ability to consult with and assist their lawyer. The extent to which the amnesia affected their ability to testify on their own behalf. The extent to which evidence could be extrinsically reconstructed in view of amnesia. So if this person has amnesia for the crime, were there witnesses? Is there security footage? Things along those lines. The extent to which government assistance, defendant, and counsel in reconstruction, basically that they can assist with, or the government can assist with sort of reconstructing the crime if the person themselves doesn't have memory of it. My notes are really weirdly worded there. Okay. And then 5 is the there we go. Someone accidentally unmuted themselves, I think. And then the strength of the prosecution's case. So if there's any suggestion that the person would be able to establish an alibi or other defense, if it were not for their amnesia, then you have to take that into account and do a proper competency evaluation. The last sort of indicator here is if any of the facts or circumstances are indicating that this is potentially not a fair trial because of the amnesia, then you need to evaluate it. Another question becomes forced medication. So if someone has schizophrenia or other type of psychosis, there are cases where medication is ordered by the judge. And these would happen in cases where they would feel there's no less intrusive way to get this person to be competent. And there's no evidence that taking the medication would be detrimental. right? You can't force someone to be on a medication that they're allergic to, for example. This is used if it will restore the person to competence and help them stay competent during the trial. Obviously, this is controversial because there are certainly people who are against any kind of psychiatric medication. And also it feels very paternalistic, right? Like sort of parenty, like, I know what's best for you. You have to take this medicine. There are other special types of competence that sometimes psychologists will also be involved with. So one is competence to waive your Miranda rights. So as we've talked about, you have to be read these rights and you can waive them. You can say, oh, no, I can talk to you without a lawyer, things along those lines, right? The waiver of Miranda rights requires that defendants, once in police custody, make a confession after having waived the Fifth Amendment right to avoid self-incrimination. And this has to be done in a knowing, intelligent, and voluntary fashion. This person has to understand what they're doing when they waive their rights. This assessment is challenging because similar to NGRI, typically the waiver and confession have occurred months before you get the person in your office to evaluate them. So now you are trying to evaluate whether a person was competent months before they're in front of you, and that can be really challenging. The Supreme Court has held that defendants have a constitutional right to waive counsel and represent themselves at trial, providing that decision is made competently. And this case was Beretta v. California in 1975. In addition, the presiding judge must be convinced that the waiver of counsel is both voluntary and intelligent. You know. Then you have to be competent to refuse the not guilty by reason of insanity defense. Can the defendant refuse to plead insanity? In some cases, the courts have suggested that only mentally responsible persons should be punished, thus requiring the imposition of this insanity plea even on unwilling defendants. So we're going to say you're insane, whether you want us to or not. And the case here was Whalen v. US in 1965. But Friedank v. US in 1979 ruled that if the defendant understands what's going on, they understand their circumstances, they understand NGRI versus a normal guilty plea, etc., they should be permitted to reject an insanity plea. They have to be competent to be sentenced. In general, to the standard for competence to be sentenced is that defendants can understand the punishment and the reasons why it's being imposed, and they can meaningfully execute their right to address the court at their sentencing. So again, this would be sort of a strange one to be brought up if they'd already been found competent to stand trial. This would often be raised if something happened in the interim. You know, they were released on bail and they got in a car accident and got a traumatic brain injury, or they've had a psychotic break. There's also a competence to be executed. The US Supreme Court decided in the case of Ford v. Wainwright in 1986 that the Eighth Amendment ban against cruel and unusual punishment prohibits the execution of defendants while they are incompetent. So basically, the person has to understand why they're being killed. In Atkins v. Virginia in 2002, they said it was unconstitutional to execute someone with, again, I hate this term, but it's the legal term, mental retardation. The idea is that someone who is considered MR is unable to understand the nature of what's going on. And again, they tied this back to the Eighth Amendment, that it's cruel and unusual punishment for someone who doesn't understand. And so psychologists will be called in to assess essentially intellectual ability. But the issue becomes, what's the cutoff for IQ? The court didn't define mental retardation. How does it relate to the functioning of the individual? Sometimes the psychologist has to use their judgment. There's also the case of juveniles and whether they're competent to stand trial or not. And researchers have found that participants who were age 15 and younger were significantly impaired in ways that compromise their abilities to function as competent defendants in an adult proceeding, an adult criminal proceeding. So this is a big argument against trying people 15 or younger as adults. Now, sometimes you have the same person who is trying to use the incompetence to stand trial and not guilty by reason of insanity. In these cases, you have to do two events. They should be done separately. So oftentimes referrals for both are made at the same time to the same clinician. And you might gather data related to both questions at the same interview or from the same contact, but they are separate, and you should keep the information separate as much as you can. You should obviously address competency first, because we can't address guilt without addressing whether that person is competent to even declare their own guilt, right? And you have to be really careful with NGRI. This idea of insanity. Insanity, I must say too, is another legal term. We don't use that clinically in psychology or psychiatry. So none of the conclusions about competence include insanity as a reason. Right? You might talk about specific psychological symptoms, but you're not talking about insanity. You can't say because they're incompetent, they're not guilty by reason of insanity. Those are two separate questions that you actually have to answer. There's also temporal issues, right? And I've mentioned this a couple times. So for competency, we're looking at present and a little bit future, right? Not only are they competent now, do they understand what's going on now, but will they be able to maintain that competency during the trial? For not guilty of reason of insanity, we're looking at past mental state at the time the act was committed. That could be 90 days ago. Depending on how long the trial process has taken, that could be years ago. That is really challenging to do psychologically because our assessment instruments are not built to do that. The key element of your response is that you're looking at the person's account of their behavior at the time of the event, and that's related to an NGRI plea. So the really interesting thing about NGRI, and again, we're going to talk about NGRI in a lot more detail after spring break, is that when you say, I'm not guilty by reason of insanity, you're saying you did it. You're implying your guilt. You have to say, yes, I did the crime, but I'm not guilty because I was insane at the time I did it. So ironically, this not guilty plea is actually also a guilty plea, right? And that's only related to competency if they can't give a coherent account of what happened at the time. So that being said, we've wrapped up with competency. NGRI is a whole thing that's going to take us a whole day, so we'll stop there for today. Everybody enjoy spring break. Hopefully you get some downtime, and I will see you in a week and a half.